Oh, March 2nd on Cantu?
Yeah.
Okay. All right, is he scheduled for jury trial?
This docket wastes no time. We've got fresh indictments, suppression issues on the table, and a defendant reportedly on hold with the U.S. Marshals. That alone raises the stakes. When someone is potentially facing federal involvement and time-sensitive plea deadlines, every delay matters. The judge is already pushing for efficiency, plea deadlines in 3 weeks, suppression issues needing quick attention. This isn't casual scheduling. This is pressure. And as we move through this hearing, you'll see exactly how the court balances negotiation, strategy, and consequences, sometimes all within minutes.
Trial?
I believe today is his first setting, yes, Judge.
All right. So was he taken into custody today?
No, Judge.
We haven't addressed it. We don't know.
Okay. All right. So, how old are you, sir?
7.
I'm sorry?
37. Right.
All right, Ms. Ferguson, set this for a plea deadline date in 3 weeks, please. What is your client's cause number?
Judge, I still don't talk about him. 2025 CR 015226.
015.
226.
It's on page 12.
All right, thank you. All right, what's happening with this case?
Judge, this is our first setting since indictment. Similar to the last individual brought up, I'm not sure why he's dressed today, but it's our first post-indictment setting. I have reviewed the office report and talked to Mr. Prater. There may be a suppression issue that both sides want to look into. We're not setting it for motion to suppress at this point, Judge, but we both want to look into that issue.
Has an offer been tendered?
No.
State, on this case, you need to tender an offer off docket. Norma, set this for a plea deadline date in 3 weeks.
February 17th.
If we can, Judge, can we put it maybe the week before that? I am on vacation that week.
All right, week before. And if y'all are intending to have a motion to suppress heard, it needs to be heard quickly because he's on hold with the U.S. Marshals.
Yes, Judge.
February 10th.
That worked for me.
All right, see you back on February 10th.
Thank
And
you,
that's
Judge.
your plea deadline date.
Okay.
All right, who's next? Raise your hand if you signed in.
I've got a plea, Judge.
All right, and
Big paperwork cover.
Giovinco.
Yes. Simon Garza was a recall last week on continuance. I think he's on the first page, Judge.
He is.
So do you want me to have him come up?
Yes.
I believe we have an agreed date.
Okay. All right. So on this one, the court had not ruled on the motion for continuance because I wanted to know when witnesses that you all wanted would be available, specifically the ME. So when is that going to be?
And I believe, Judge, considering their schedule along with all the other witnesses' schedules, the best date for this would be around March 17th.
And have you all conferred with Ms. Ferguson?
No, Judge, I have not. We can do that.
Norma, do we have a March 17th date available for jury trial? All right. So we're on the record in 2025 CR 004128 State versus Simon Alexander Garza. Can I have parties announced?
Brandon Prater with the state.
Marissa Giovinco for Mr. Garza.
And are you Mr. Garza?
Yes.
All right, we were here at the last setting. Both parties had filed an agreed motion for continuance. The court will grant the agreed motion for continuance based upon the unavailability of the ME. And you all have agreed on a jury trial date of March 17th, 2026. Is that correct, State?
That is correct, Judge.
Defense, is that correct?
Yes, Judge.
All right, once you sign the reset form, you'll be excused and you'll be back on March 17th for jury trial.
Thank you, Judge.
Thank you. You're welcome. Who else has signed in and it's not a plea and you're ready? All right, yes, who do you have? Is calling 2025 CR 014278, State versus Veronica Callahan. Could I have parties announced?
Matthew Allen for Miss Callahan.
And are you Miss Callahan?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Callahan, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state nurse to wait the.
No objection.
Ms. Callahan, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I'm sorry, it's
This moment is critical. The defendant is facing a third-degree felony, evading arrest with a vehicle, carrying a punishment range of 2 to 10 years, and up to a $10,000 fine. The judge carefully explains deferred adjudication, which many viewers misunderstand. Deferred adjudication is not a dismissal. It's conditional mercy. If she violates it, the court can sentence her to the full 10 years without a jury trial. That's a huge legal risk. Notice how the judge emphasizes rights being waived, jury trial, confrontation of witnesses, right to remain silent. This is the constitutional safeguard moment. So here's the question. When someone chooses deferred adjudication over trial, are they making a smart strategic move or gambling on perfect
I'm
compliance?
sorry, it's the court.
This document telling you what you're charged with and what your rights are. Did you review that with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Mm.
You're charged with evading arrest detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Callahan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is waiving the enhancement. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's a $1,200 fine. The state is opposed to your application. They're taking in consideration 2025 CR 014278. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers states exhibit 1 in all attachments.
No objection.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt. Counsel, if you're requesting a PSI, it's going to be 8 to 12 weeks. If you want to have it brought back sooner with just the court hearing from witnesses, we can set it sooner.
We request a PSI, Your Honor.
All right, I need a PSI date. All right, we'll see you back on April 14th. Do you want a TAP evaluation as well?
No, we're not requesting one, Your Honor.
All right. Probation is just be PSI, no TAP. Once you sign the reset form, you excuse, please speak with probation before you leave.
Thank you, Judge.
You're welcome. So what is your client's cause number? Do you have it?
2025 CR 010159.
And it's Victor Salinas.
Yes, Judge Guzman.
So where are we on discovery?
I don't know. This case was transferred from the 399. I need to look at it. I suspect that we may need to have a lot more of it since the pets were involved in the investigation and the arrest. And so what I can see from the file is just SAPD reports and some evidence, but I know HSI and DEA were involved in it too.
All right, State, on this case, will you be able to get the information from other agencies?
My apologies, Judge. This is going with the federal.
Yeah.
Mhm.
Judge, I believe we're in contact with the AUSA that's involved, so I believe we've got it.
All right, Ms. Ferguson, recall this for 30 days for discovery. All right, we'll be back on February 26th for discovery.
Thank you, Judge.
anything else?
That's it, Judge.
All right, thank you.
Thank you, Judge.
Toma asiento.
Thank you.
Judge.
Sure. Who's here on Bob, Vu? Court is calling 2025 CR 006190 and 2025 CR 006189 State versus Bob Vu. Could I have parties announced?
Right, ready for the state?
Attorney Bill Sims for defense.
And are you Mr. Vu?
Yes,
Counsel, in each cause number, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Vu, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictments as presented?
We are, Judge.
Mr. Vu, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
yes,
And the cause number ending in 90, you're charged with criminal mischief, $2,500 to $30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 89, you're charged with assault on a peace officer or judge. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your pleas and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
yes,
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
there is no contest.
No. You have certain rights. Do you understand what your rights are?
Yes, yes,
Do you understand that you have a right to go to a jury trial?
yes,
Do you understand you have a right to have the state present witnesses to give testimony against you, and you have a right to cross-examine those witnesses? Do you understand?
yes,
You're giving up those rights to enter into this plea, is that correct?
Yes, and
And is that what you want to do?
please no contest.
Looks like,
saying you give a whole bunch of shitty drops, do you assume to move forward to do you feel like you want? Is that what you want? So the answer to the question is yes, that's what you want. We talked about homelessness. You understand?
All right. Do you understand the rights you have?
Yes, and
Do you understand when you enter into a plea bargain agreement, you're giving up those rights?
yes, and
And do you want to give up those rights and enter into a plea bargain agreement in each of these cases?
yes, and
I'm sorry?
This exchange right here shows why judges insist on verbal clarity. Head nods don't count. Mispronunciations can't substitute for clear consent. The court has to ensure the plea is knowing and voluntary, meaning the defendant fully understands the rights being waived. When Mr. Vu stumbles over answers, the judge slows everything down. That's not hostility. That's constitutional protection. A plea must be crystal clear on the record, or it can later be challenged. And then comes the weight of the agreement. 2 years in state jail on one case, 2 years in prison on the other, running concurrently. So ask yourself, would you take 2 guaranteed years or risk trial on a second-degree felony carrying up to 20 years?
yes, and
Yeah, he said, yes, he does.
Yes.
Is that what you said? Yes, you do? All right, so the head nods, the court reporter can't take down head nods. You're going to have to say yes or no.
yes, and
All right. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Vu, in each of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
yes, and
Has anyone threatened you to get you to enter these pleas?
oh no, and
Has anyone promised you anything other than the plea bargain agreement?
no one.
Are you satisfied with the way you've been represented?
Yes,
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry into the United States. Do you understand?
yes, I understand. I'm a U.S. citizen.
Here's the thing. I'm just asking questions.
Yes.
All right.
Your
Court,
Honor, I think he's just trying to say Your Honor, and he's just mispronouncing
Yeah.
that. Like at the end of it, that's what he's trying to say is Your Honor.
I understand. I'm just asking questions. I just would like my questions to be answered. All right. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement that you've reached with the state with you and your attorney?
Yes, and
Okay. So in each cause number, you've agreed to a 2-year sentence. State jail felony case, you've agreed to a 2-year sentence. The case that is a second degree, you've agreed to 2 years in the prison. So one is 2 years in the state jail facility and one is 2 years in the prison. And the cases are running concurrently. Did you understand that to be your plea in each of these cases?
yes, and
Defense,
Yes, Your Honor.
state.
It is, Judge.
All right. Did you review the waiver of appeal paragraph in each of these cause numbers?
yes,
Did you understand it?
yes, and
Did you sign it in both places?
yes, and
All right. Now, by signing that, you're waiving your right to appeal. The only thing you will be allowed to appeal on is if I've heard some type of pretrial motion. Do you understand?
yes, and
And that I've ruled on that. Do you understand?
yes, and
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2025 CR 006190, how do you plead? Guilty, not guilty, or no contest?
please no contest, Ernest.
Okay. And in cause number 2025 CR 006189, how do you plead? Guilty, not guilty, or no contest?
Please no contest, Ernest.
All right. State, do you have any evidence to support the defendant's plea?
Yes, Judge, we offer Exhibit 1 and all attachments on both cases.
No objection.
Mr. Vu, in each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it
Yes, and
in all the appropriate places?
yes, and
Now, again, you have a right to jury trial, a right for you or either your attorney to question any witnesses that the state would call, and the right to remain silent. Do you understand?
yes, and
Because you've entered into this plea bargain agreement, the state is not bringing any witnesses in today. They're proceeding on the police reports that are in these stipulations. Do you understand? And each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And each cause number at the reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty in each cause number. And in each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, and
Anything you wish to say on behalf of your client?
We'll just pray the court follow the plea agreement.
And cause number 2025 CR 006190, the court will sentence you to 2 years in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 006189. State you're excused.
Thank you.
There's to be no contact with Walmart located at 8923 Military Drive. And that's 78251. And cause number 2025 CR 006189. The court will sentence you to 2 years in the prison, give you credit for any time served. This will run concurrent with 2025 CR 006190. Counsel, was your client having a bad day that day, or what was going on?
Bad day, homeless. He thought the person was following him and harassing him, and he responded in a way that he knows that he shouldn't have responded.
All right, and the court will request the therapeutic community. The therapeutic community does not increase the time that you're in custody, but it's to help you with any issues you may have. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Today's docket shows how layered criminal court really is. We saw plea deadlines tightening for defendants under indictment. We saw deferred adjudication granted with serious consequences if violated. We saw federal agency discovery issues that could reshape a case entirely. And finally, we saw a negotiated plea resulting in concurrent 2-year sentences for a state jail felony and a second-degree felony. But what stands out most is the human element. Even after sentencing, the judge offers help for homelessness, showing that accountability and compassion can exist in the same courtroom. This hearing reflects the balance between procedure, punishment, and second chances.
Stand it and sign it.
yes, and
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand?
yes, and
All right, Ms. Savu, we're off the record. Your attorney has told me that there may be some homelessness in regards to you. When you're released from custody, if I'm still here and you can't find a place to help you with that, you come back here, I'll pick up the phone to call somebody to see if maybe the Salvation Army or Haven for Hope or there's some other placement for you.
yes.
All right, good luck to you, okay? You're welcome.